All right, good morning, everyone. Thank you so much for being with us this morning. My name is Cassie Hopkins, and I help coordinate the webinars for Hausman Johnson Insurance. I would like to welcome you to today's webinar, Discipline and Documentation Advanced. Just so that you are aware, this webinar is interactive and will feature a question and answer session. You can type a question in at any time during this webinar, and Karen will address it at the end. After the webinar is over, there will be a short survey we are hoping you can fill out for us to give us feedback on the webinar and other webinar topics you might be interested in learning more about. This webinar is recorded and will be available on the webinar archive section of our website, and you will receive a follow-up email with a link to the recording and the presentation slides. I would now like to introduce you to our wonderful speaker, Karen Bender. Karen joined Hausman Johnson Insurance in 2017 with over 30 years of human resources experience. Her experience includes regulatory compliance such as FMLA, EEO, FLSA, HR and safety, benefits, wage and salary administration, employee relations, training, and payroll. The majority of her industry experience is in the insurance and manufacturing industries, and she is knowledgeable in both union and non-union work environments. Karen also provides training services to UW-Madison Small Business Development Center in HR areas and instructs a class for the UW-Madison Division of Continuing Studies. Further, she developed and teaches courses targeted at providing small businesses, less than 100 employees, with general HR guidance and employment law review to help them maintain compliance and improve their processes. Karen enjoys working outside, spending time with her family, reading and traveling. She has traveled to, get this, over 23 foreign countries so far, including hiking throughout Europe, a 1,000-mile snowmobile trip in Canada, and exploring the beaten path in China. We want to welcome you today, Karen. Thank you for being with us.
Thank you, Cassie. Thank you. Good morning, everybody. Today we're going to talk about discipline and documentation, but in some of the more advanced issues that you might have to deal with. So this is kind of a follow-up to my basic documentation and discipline presentation and webinar. That is available on the Hausman Johnson website. We'll talk about that later. I'm also going to talk a little bit about freedom of speech. When you start getting into disciplining people, sometimes their retort will be, I can say and do whatever I want. We're going to talk about that. We're going to talk about people who refuse to work or disrupt your work site due to COVID or for other reasons. I'm going to bring in COVID, and this is a very timely thing because of people's resistance to working on site or following your rules, and it's become a big issue, and we've been getting a lot of calls on that. What do we do? So even now, we're going to talk basically, briefly about refusing to work with someone that's in a protected class. We're going to talk about safety concerns and safety violations. Some of these will be could be COVID related or not. So when I talk about safety today, don't think of it as only in the context of manufacturing or construction. Even if you're in an office environment, you still have safety responsibilities. Political opinions, we're going to talk about that. Everybody's got one, but do we want to hear it at work? We're going to talk about remote workers, and we're also going to talk very briefly about performance issues with senior employees. Okay, Cassie? I am not an attorney. I have, like Cassie said, over 30 years of experience in HR in a variety of environments, and I've also done a lot of training. I've done research, etc., in order to prepare in order to prepare for this class, but I am not an attorney. And if you need an attorney and you're in a tough situation, get an attorney, because it's much cheaper to do that than to continue down the wrong road and pay more in the long run. Okay, but before you start to discipline, make sure that you've done everything you can to make an employee successful. Many times there are people start down the road of discipline only to discover that maybe the employee didn't know what they were supposed to be doing. Maybe they haven't been provided training. Maybe there's an obstacle. Somebody's supposed to provide them information before they can provide it to you, and that person isn't doing it on a timely basis. Are these all removed? And then bottom line, do they have the ability? If they don't have the ability, discipline may not be the right next step. But if any of those barriers are in place, then discipline might not be the next step. Typical steps are, in your situation may be different, but typically there's 4 or 5 steps, but it varies depending on the organization and it varies depending on the situation. Next, and typically your progressive discipline policy should allow you discretion to determine what's appropriate based on the circumstances. You want to make sure that that policy is flexible. When you document, talk about who, what, when, where, but not why, unless the employee gives you an explanation. There's a lot of details that should also be in that document. Go ahead. And the discipline written discipline should have 3 parts to it. It should briefly talk about the infraction, talk about the expectation, and talk about the consequences of future incidences. So for example, if you don't want to use something like that says you ran bad product and you didn't fix it, so that doesn't help the employee. So what you would want to say is a much more detailed explanation of what the employee did wrong. They allowed poor product quality. They had lost the value of the lost product and your expectation, and then this comment that I put on all of them is future infractions will result in further disciplinary action up to and including discharge. So you want to make sure that that's done. There's other options: notes to file, adding steps, demotions, last chance agreement, severance, etc., prior to discipline and documentation. So I hit on those topics very, very briefly. But in the 1-hour webinar that is archived on our website, was done earlier this year, I go through those issues in detail. And we talk about it more and why it's important and how to do it. There will be a half-day class available again in the future. We've done these in the past, and I go into much more detail about the documentation and discipline process. And I can also do company-specific training upon request. I want to talk about different scenarios that often are difficult for people to deal with. The first one that we're going to talk about is freedom of speech. Let me back up. We talked briefly, very briefly, in the intro part, I talked about documentation. Documentation is the backbone of your discipline policy. It is the backbone of being able to defend yourself in any kind of situation. You as a leader or any of your leaders can do all of the right things. They can talk to the employees, they can coach them, they can counsel them, they can train them, and then just go through all the steps and do, bend over backwards to make somebody successful, and the person can still fail and be terminated. Well, if that person then files for unemployment or files any, for any charges or anything else that, they feel like they need to do, you're going to go before a judge. And the judge will say to you as a company, did you talk to this person? Did you counsel them? Did you do all of the proper things and give them warnings and write it out? Did you give them warnings? Did they know what they were doing was wrong, etc.? You're going to say yes, because you did do all of those things. The employee may say no, they didn't do any of that. The judge will turn back to you and say, where's your documentation? If you don't have documentation, even if you did everything right, if you don't have the documentation, the judge will find for the employee. Now, you did everything right. Why are they finding for the employee? It's because as the employer, it is your responsibility to document. And if you don't document and can't prove you did what you said you did, then they will fine for the employee because you didn't do your job. So even though you did everything right, if you didn't do your job and document, that's what you need to do. So I talk a lot about documentation in the first session, first hour. So let's go to freedom of speech. When you talk to some of your employees, they're going to say, I can say whatever I want, especially if you're talking about politics or somebody is being rude or harassing somebody else. A lot of times when you start discussing these issues, they'll say, I can say what I want, freedom of speech. That is not true. Your response should be a very calm, no, you can't. Freedom of speech does not protect employees and allow them to say anything they want to in the workplace unless you work for the government. Because the idea of freedom of speech is, next slide, is that it's the First Amendment, as we know. It gives employees zero protection at their jobs. It allows people to talk about their opinions without fear of government censorship, but that is not the same as employer controls, employer policies, etc. The government can't shut you down, but the rest of the world can react to those. In other words, you can say what you want, and the government can't in the workplace. And the government can't shut you down, but the rest of the world can react and shut you down, or your employer. So you, as the employer, can and must set reasonable expectations for behavior in the workplace, including speech. If you don't set reasonable expectations for behavior, then the employees will make their own rules. And that probably won't go in the direction of your best interest. You can and must set reasonable expectations. So there is no freedom of speech, legal protection for your employees if they violate and share confidential information and trade secrets. There's no protection for harassment and or discrimination. In fact, the opposite is true in that situation. They must not, and the laws require that they must not say things that are inappropriate or discriminatory. There is no freedom of speech for profanity, or for controversial political views, or rude jokes or comments. So on this link, or on this slide rather, I've attached a link where you can go for further information if your employees are telling you that they have the right to say what they want. Now, with the current the division in the political opinions and views, you may be hearing this from people, and that is not, this will give you the information to be able to reply knowledgeably on what your rights are as the employer. Okay, so let's go to one exception to this is concerted activity. The NLRA is the National Labor Relations Act. It's the foundation for collective bargaining and unions. The National Labor Relations Act protects your non-supervisor employees. and gives them the right to discuss wages, hours, and conditions of employment without restriction. That means that it is legal for them to discuss with each other what their wages are, what their hours are, and comments about the conditions of employment, and you cannot restrict that. That means that they can make nasty comments about you, and they can make comments like that if even on the internet and social media in many cases. If your employees are bad-mouthing you or lying about the company or doing anything else online, do not assume that they cannot do that. If an employee says something and another employee jumps in, that's concerted activity. And you want to be careful before you react to something like that and say, well, you can't say that online. That's not true or whatever. Before you act on something that you see on the internet or on social media that was posted by one of your employees about you or by the company or about other employees, contact an attorney and see if you can even do anything about that and what is the proper response. Okay, now we're going to talk about the COVID complainer. I labeled this the COVID complainer, but this process can be followed for many other instances of pushback. So for example, if you have an employee who wants fresh air and keeps wanting to open the windows and doors, but that violates maybe your safety and security policies, or they just push back on anything you want to do. You want to change brakes, you want to do this, you want to do that, and they push back on everything. This is a process that you can follow. So let's use the scenario that you have instituted all the safety requirements and precautions, and maybe you even exceed the safety precautions that have been set for us. Well, and the employees are returning to work, but somebody is complaining vocally that they don't feel safe and they are disrupting the workplace, maybe upsetting customers or clients and being very vocal and inappropriate in the workplace. What do you do? So first of all, have a non-confrontational fact-finding discussion. What are their concerns? COVID is going to be different than almost any of the other things that we're talking about. In particular, COVID brings so much emotional baggage and so many personal circumstances that individual circumstances and stressors that we can't possibly know about it. So please, in the examples of a COVID complainer, please talk to them and be open-minded to the fact that they may have some stressors and some serious issues that are legitimate that you don't know about and they maybe need to take into account. Maybe they have a young child that is very susceptible or to COVID and has underlying health conditions. We just don't know all of the situations, and there are some people who are terribly afraid, and legitimately so, and there's just so many different circumstances. So please take the time in this case to be compassionate and understand their fears. Then if you've done that and you think, okay, we have done all this, we've addressed this, and let's say it's an issue that they say they can't breathe through a mask, they have a medical condition and they can't breathe through a mask. That's probably not true, because people with medical conditions that are affecting their breathing are highly, possibly more susceptible to COVID, etc. And so if they say that they medically cannot breathe through one of those, consider requesting a doctor's note or figuring out another way to allay their fears. There's different things other than masks, the shields and stuff, they can be used. So be open to accommodating that situation for a COVID complainer. But now let's say that it's a similar situation with, you've done everything, but they're being even vocal vocal in front of your customers, or they're riling up other employees. Now what do? So you've had an initial meeting. You know, you understand their concerns. You don't think they're legit, or maybe you do, but that doesn't mean that they can continue to make observations, comments, etc., in front of clients or other workers. You can still require them to focus on their job and not be disruptive. So after you have that initial meeting with them where you talk about their concerns and legitimacy and work out their possible resolution, at that meeting, ask for their cooperation and tell them that if they continue to be disruptive to the workplace, that's separate from the safety issue. The disruption of the workplace by talking in front of other people or getting them riled, or whatever their actions are, is separate from the COVID issue of safety. And then document the conversation and send them a copy. If this bad behavior continues, consider a write-up at, the next step, whatever you think is appropriate. The first step was probably a counseling. If the bad behavior continues, you might want to consider a write-up, like a first written, if it's bad enough. But look and see, has this employee had previous issues? Have you written them up for other issues of resistance to your policies, your procedures, disruption, gossip, anything like that? Have they had prior issues, and were they disciplined for them? Because if they were, then this is just building on that case, and maybe they're not due for a first written, maybe they're due for a second written, or maybe even a suspension. You have to look and see how old they were and if they were related. Okay. So if it continues after that, you may have an insubordination issue. People use the term insubordination incorrectly many times, so I thought it was important for us to understand the legal definition of insubordination. Before you write somebody up for insubordination, you want to make sure that you know what you're talking about. It's an employee's intentional refusal. So it's not that they have, if they don't have the ability to do what you're telling them, that's not intentional refusal. But it's an intentional refusal to obey lawful and reasonable orders. And it undermines the supervisor's level of respect and ability to manage, and is often a reason for disciplinary action up to and including termination. So let's say that, next one. So if it is intentional, and you're going down that road and you instruct an employee to wear their mask, that's your rule. Maybe you're, the guidelines, I'll say that, and you're telling an employee to wear their mask or leave that door shut because of safety, whatever. If before you go down that road, go back to that one of those first slides that we talked about. Do they have the knowledge, the ability, the understanding? Have you removed the obstacles, etc., so that they can comply? If you have had previous conversations with them, you've probably already established that. Then in this situation, you're now going to be facing the employee on an insubordination issue. Clearly, calmly state your expectation. And if it's appropriate, if you've had prior conversations with them, remind them of that. Sometimes you will run into a situation where you're telling an employee what to do, and it's an insubordination situation, but you haven't had any conversations about it. They just know what the rules are. Remind them of the rules and ensure they understand what you're asking them to do. If they understand, if they say, yes, I know, but I'm not going to do it, or they just flat out continue to refuse, you may have an insubordination situation. So what you do in that situation is you can address the insubordination and write them up for insubordination. But then that will depend on what have you done in similar situations. Have you written up people for insubordination when they clearly understood what they were supposed to do and didn't do it, refused to do it? Have you written them up in the past? If you have not written them up in the past and you're going to select this person out, you better make sure that they are either the worst offender or that you've made the rules clear and said from now on, if you refuse to do what we say, you will be written up. Because if you've ignored this behavior in the past, you're going to have to draw a line in the sand and tell people, post it, send out an email or whatever, and say, going forward, if you refuse to do this, this will be the response. Then they've been put on notice. But you can't change the rules midstream and expect the employees to think that they've been treated fairly. So make a work rule if that's what you have to do, and make sure, or a policy, and make sure that you communicate it. The seriousness of the offense will also, the incident, the number of issues that you've had with the employees will all affect what you determine are your next steps. Is it going to be a written? Is it going to be a first written? Are they due for termination? All that stuff, you have to look at the past to see what's appropriate for that situation. Okay, thank you. Next slide. So let's say that you have an employee who refuses to work with an LGBTQ employee. You recently have probably saw that the Supreme Court ruled that sexual orientation is covered by the harassment laws. So this is, and there was disagreement on that until recently, but the Supreme Court recently ruled that. You will not see any new laws coming out because of that. It's just a confirmation that the prior laws we had on anti-discrimination and harassment, LGBTQ employees and persons were covered under those laws. So have you trained your workforce on harassment, bullying, sensitivity? The last several years, many employers have done harassment training because of all the sexual harassment issues that have been in the news. The sensitivity training because of all the other issues that have been in our news. So you might have done some training on these issues. If you have not, please understand that the state does not require you to do this training. However, that is your best defense if you get any charges. If you've done training so that you've told your people what's the proper thing to do, what's the proper way to react, how do you report harassment, that's the first step in setting up a program to avoid this. Your employees need to know your expectations, that you expect them to treat everybody decently, with civility. And then you have to look at whether or not you as the management team are demonstrating proper behavior. Are you doing what you should be doing when you see bullying going on, when you see people being insensitive? Are you doing what you're supposed to be doing? Because if you're not, they're not going to, the employees are going to follow your lead. So make sure you're doing the right thing. So if you have done the training, it will help, but it does not take care of the feelings or issues that are occurring if that all you do is tell your employees what they're supposed to be doing. You have to demonstrate in your actions how to behave and address any fears and concerns that people may have for dealing with for being an employee that's LGBTQ or working with somebody, because people have a lot of fears in dealing with the unknown. So if somebody if you've done your training, that's one thing. But if you haven't done the training, you will, and you've received a harassment or discrimination complaint, you will have to do an investigation. Whether or not you've done the training, you have to do an investigation. Investigations are hard. There is proper procedures for doing those. And if you don't know how to do them, make sure that you get help. If there are harassment and discrimination complaints that go unaddressed, they can escalate. They'll continue to boil, and they can become workplace violence. Or short of that, they may cause good employees to leave. They'll think, I don't have to deal with this, and they'll leave. So you want to deal with it from the standpoint of proper employee relations. You want your employees to know that you will do the right thing in a tough situation. But if you've already got a complaint, do an investigation. You can't ignore it. You can't ignore it. You have to do an investigation. The amount of investigation depends on what the situation is and how serious it is. Sometimes it's a he said, she said, and sometimes it's a much more serious, widespread issue. So we are not talking about the investigation process during the webinar because it's very complex. It's very complicated. So we're not going to talk about that now, but make sure that you know, or get some training, or get somebody in that knows how to do a proper investigation if you have a complaint. So if you were made aware of a situation prior to a complaint, that's exactly what you want to happen, because you want to avoid the issue coming to the level of being a complaint. So again, if you have a non-confrontational fact-finding discussion. So if an employee is resistant or refusing to work with an LGBTQ employee, again, it's very similar to what we talked about when we had the employee who was resisting with the COVID. What are their concerns? If they're religious concerns or anything like that, we will talk about religion later. Sometimes they're based on personal views, personal values. Maybe it's, they think that, they've all got AIDS. When AIDS first became an issue, I had employees that were hesitant. They didn't come right out and refuse, but they made noise about having to work with an employee that they believed was gay. And they said, because he's got AIDS, and they started, that rumor. So it's you don't know what they're capable of or what's going on in their minds. So you have to ask, what is the issue? And maybe you need some education. Maybe they need some education on what that's all about. And that the fact is, the law says that they are protected. You have to have a position and a commitment to a harassment-free environment, regardless of what you think or what the employee thinks. The law says this is the way that we will treat people, and your personal opinions don't matter. You have to uphold the law. So again, during the initial meeting, ask them what are their issues, address them as appropriate, and then advise them at the end that you expect their compliance and cooperation. Again, document. Maybe that's a note to file, maybe it's a counseling, and you send them a copy. But then if the bad behavior continues, similar to the COVID issue that we talked about before, consider disciplinary write-up steps. Now let's talk about specifically, next slide. If they are refusing to work with somebody because of their legitimate religious beliefs, not made up beliefs that they're attributing to their church, but legitimate religious beliefs. Bottom line is, the employee's religious beliefs do not trump the federal law. So, unless you are a church or a faith-based organization and they are identified narrowly in the law, then you have to explain and enforce the rights of the LGBTQ employee. You cannot discriminate against them. I know there are some organizations out there where the leaders are extremely religious. And I've had employees tell me that they've been required to participate in morning prayer in order to work at the organization, and that they've done different things like that. And these were not religious organizations, they were private sector companies who had leaders with strong religious beliefs. Those beliefs do not meet the law. You cannot discriminate against somebody because of their LGBTQ status or anything else because of religious beliefs. Okay, so next issue is safety violations. Again, I'm going to take this much broader than just manufacturing or construction or anything like that. So when we talk about safety, don't limit your thoughts to that. So let's say that you have one employee or several employees who are not following your safety rules, and it puts them in danger of contracting COVID or some other accident, illness, or exposure. You all know that if you go into the hospital or doctor's office or anything like that, even prior to COVID, they were taking precautions to protect themselves. So, and if they weren't doing that, then they were often disciplined, or they could lose their job. So for example, a nurse cannot refuse to wear gloves when they're doing different medical procedures. Doctors don't refuse to wear gloves during medical procedures because that's part of protecting employees and patients from accidents, illnesses, and exposures. OSHA provides protection, but COVID just erased those expectations and spread those expectations so much further. But OSHA provides protection for employees from discipline or retaliation for reporting safety concerns to OSHA. So what that means is that if your employee thinks that you are violating a safety rule, they can call OSHA. Sometimes they call OSHA even if they don't think you're violating rules, because they want to get you into trouble. And the employees think they can get you into trouble with this. OSHA knows that the employees are doing this, and that's not always true. So, but they will call and follow up. They have the legal right to do that, and you cannot discipline them for calling in and saying something even if it's not true. They have the right to report that. So make sure that you are not disciplining people for reporting safety concerns. But if you are not doing any disciplining for anything right now, you might want to consider taking a different approach. Especially in the area of safety, and you may want to select that one as a place to start if you're most comfortable. Because if not, you may have a situation which is a failure to protect your employees. Under the general duty clause of the OSHA standards, the employer has to protect the employee. They have to provide an environment which is generally free of hazards. And if you are not doing that, you are failing to protect your employees, and there is the potential for increased penalties on you if there is an injury and you have not done what you're supposed to do to protect an employee. So if you want to be clear and careful with your safety rules and expectations. If people are required to wear safety glasses or to, keep the doors, locked for employee protection, anything like that, wear safety glasses. Or then in manufacturing and construction, there's hundreds of safety rules to keep people safe. In the offices, there's less, but there's still issues, and you need to be clear on how or what the safety rules are and how you expect the employees to comply. You must ensure, and it's your responsibility as the employer, that you provide all necessary training and tools, and that you have to clearly, if the employee does something wrong, you have to clearly communicate to them what they did wrong and how to correct it in the future. Let's go back to the fact that earlier on I talked about the example of stating the infraction, stating the expectation, and stating the consequences. Use it as a teachable moment. I had a situation when I first started in my career where my plant manager, I was the HR manager, and my plant manager in a manufacturing site said, I hear you're too hard on the employees. And I said, well, what am I doing wrong? I knew a lot of things that I had done, but I didn't think any of them were wrong. And I said, what am I doing wrong? And he said, oh, I don't know. That's all I'm hearing is that you're just hard on the employees. Well, obviously that lesson stuck with me because that was over 30 years ago, and it was absolutely worthless. If you're going to talk to somebody about anything for discipline, make sure you're clear on what they did wrong, because I wasn't even able to respond, so I wasn't able to tell him what I had done to see whether or not I had been doing the right things. So I think it was a lesson for both he and I that now, when I talk to people about things that they've done wrong, I'm pretty clear. And then I talk about the expectation and the consequences, because it's worthless to tell somebody you messed that up without being able to tell them how. Or on the reverse side, you did a great job without being specific on what they did right. Next slide. So if you're with safety violations, because OSHA is involved and potentially work comp may be involved with safety violations, that's why I've separated that one out from the others, is because it's different in that you have a legal responsibility under the OSHA Act to do this, or to protect your employees. If your employees are violating your safety rules, make sure that you are doing proportional, fair and proportional disciplinary action and more severe action if violations are repeated. So for example, the first time, if somebody's not wearing their hearing protection, you may tell them verbally. Like the third time, you may write them up. The fourth or fifth time, you may start, the first time you write them up, it'll be a first written, second written, third written, and go all the way through the process. Well, should somebody be terminated for not wearing their earplugs? Well, yeah, maybe. If there is a reason, if there's noise in that area, they are at risk of losing their hearing. They're also violating your work rules. So there's two issues going on there. Is that the risk is that over time a hearing loss, but the violation of the rules is also something that you do not want to tolerate, because if one person gets away with it, everybody will. You will take more serious action in a more serious violation. Let's say that you have forklifts and somebody is being an unsafe driver and not following your rules. If there's an accident the first time that they do that, they're going to take that a lot more seriously than just a counseling. Especially if somebody gets hurt. You have to look at the risk and the nature of the violation. If somebody is being careless with the forklift, even if they don't have an accident, you still want to deal with that severely, because the potential for an accident is very high and the severity of it is very high. If you start dealing with issues like that and saying, you know what, this is the rule. I am trying to protect your hearing, and I am trying to protect the other employees. I am trying whatever it is, and focus on their safety and say, I need you to comply. You need to comply to protect so-and-so and so-and-so or yourself. You'll demonstrate that you do care about their safety, because it's not easy to stand up and say, you know what, that's enough. We're going to write you up. Also, then, if there is a violation or if there is any issue, it demonstrates to OSHA that you took your responsibility seriously and you took the appropriate action to ensure employee safety. You did the training, you provided the tools, you did fair and progressive proportional disciplinary action, and of course you've documented it so you can show that to OSHA in the event of an inspection or a work comp if you need it for a specific claim. If somebody is saying that they weren't trained and they have a serious injury, you need this to support yourself in the position that you've taken and that you have reacted. Okay. Let's go on to political opinions and signs. Oh my gosh, everybody's got one of those these days. Bad things can happen at work when we allow these opinions and emotions to enter into our workplace. Of course, people don't leave their opinions and their emotions at home, but as an employer, you can prevent them from stating their opinions and managing their emotions. You have the right to, and you must prevent problems by establishing policies, again, that deal with general behavior. We talked about earlier on that if you don't set policies telling your employees how to behave, they'll decide and they'll set their own policies and rules. Employees don't have a constitutional right to discuss their views at work. You can make rules, and you probably should make rules that say no political signs, no political t-shirts, no hats, no signs at your work site, none of that, because they don't have the right to do that. And if these divisive times right now would be these things can escalate, and it can create a hostile work environment in the fact that somebody gets so uncomfortable that they can't come to work. Keep it out of work. I even had one employer, an employee had a sign in their car that was inappropriate and offensive, and they would not let them park in their parking lot anymore. They said, you know what, that violates our company standards, our company rules. We don't stand for that. And they said, you can't park in the parking lot anymore. And the person was forced to park on the street because they refused to remove remove the sticker. And then when I saw the sticker, I could see why the employer said, you can't park that vehicle in here. You do have the right to control what's going on in your workplace. And the employees don't have constitutional rights to discuss their views. And again, they will probably say, freedom of speech, I can say what I want. Now you know they can't. So let's talk about the policies that you can have. You can restrict posters and other campaign material. You can and should take them down. If somebody says, hey, that's mine, that's okay. You can have it back, but don't post it here. Wearing t-shirts supporting proposed laws. Again, you can and should make them change or cover the t-shirt. Make them change their clothes, send them home. If they've been told and they know and they come in with it anyway, send them home, tell them to change and come back. If they don't come back, they've lost a day of wages possibly, or turn the t-shirt inside out, or have somebody else give them a shirt. Soliciting others is not, you do not have to tolerate that. You don't have to solicit, you don't have to tolerate them soliciting others. Now, if people want to say, get out and vote, that's not, that's not going with either side. You're still going to somewhat want to limit that, because then that escalates into a discussion of which side you want them to go. But that's up to you how you handle that. You do not have to allow them to use company mail to disseminate political information. And again, you can create policies that restrict this, and then people who violate that are violating company rules. It's not, you can discipline them for violating company rules. Let's go back to, let's say that the person that you're disciplining is expressing a political opinion that's different than yours. They might say, you're only writing me up because you're of the other party. The answer is no, I'm writing you up because you violated a work rule. Same with safety. If somebody gets hurt because they violated a work rule, don't write them up for getting hurt, write them up for violating the work rules. Focus on the policy, focus on the rule, and you have to have them in place in order to enforce them. So also in political opinions, there is another exception. Again, the NLRA says that the political message has anything to do with workers' rights. For example, minimum wage. If they wear t-shirts that say raise the minimum wage, you'll want to review this article before you do anything about that, because there are times when you have a concerted activity issue, and that's what this would be, where the NLRA protects the employees if that's a message on workers' rights. So just use that precaution when you're dealing with those issues now. Okay, and again, if you have to deal with people, if you found somebody as a poster in somebody's office that you thought or that supported a specific party, and they've been, or that same person has been making political comments, but of course they don't do it when you're around, you still have to tell them to stop. You still have to take down the posters. You can tell them, take it down or I will, but you can take down the posters. If you don't know, if the posters are hanging on the bulletin boards, take them down. Take them down. It doesn't matter if you agree with them, take them down and be consistent with that. So again, have a conversation with the employee. Do they know the policy? Ask for immediate cooperation. Ask if they understand, and document but verify that they still took it down. If they say, yeah, I'll take it down, yeah, I'll take care of it. Document the conversation, but still verify that they did it. Then again, next slide. The same issues as we talked about before. What next steps you take depend on what you have done in the past. Let's talk about remote workers. So remote versus face-to-face, I'm gonna have to kind of pick up my pace. Disciplining and coaching employees used to be face-to-face. Now it's often a phone conversation or a video chat. There will be, we're going to talk about recording a discussion, but before you talk to somebody and discipline or coach or counsel somebody over the phone or on a chat, write out your notes so that you know what you're going to say and be prepared for that. If you have disciplinary action forms, you can send that to them before the meeting if you want, if you're using those, or you can send it to them after the meeting. Then after that phone call or conference call, follow up with a written email or a memo to the employee outlining the discussion. On such and such a date at such and such a time, you and I discussed the fact that this happened, what our expectations are, and what the consequences are. You responded, da, 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 da. Ask them to acknowledge receipt or let you know, do you remember things differently? Do you think that that's not what you said or not what I said? Give them an opportunity to respond, but preferably have them do it by email so that you have that record. And if they call you with comments and concerns, ask them to, again, follow up the conversation. Ask them to put their concerns in an email if you want to. If it's a very highly emotional situation or one that has a chance to become a big issue, then ask them to put that into an email, and then you can respond to them via email too, because that excuse me, allows you to have a document of there's your documentation of your actions. Mary Jo did a blog on working with employees remotely. There's a link for that. Let's talk about recording. The state of Wisconsin allows you to record a conversation if one person, maybe you, knows the conversation is being recorded. But remember that the technology you're using may tell the employee they're being recorded. For example, right now, I can see that this is being recorded. So even if you don't tell the employee, technology may show them that they are being recorded. And be professional, because they may be recording you even if you're not recording them. And other states have different laws. So let's talk about, what if the leader is the problem? The leaders, I don't know what your position is in your company, but we all know that some leaders are not effective. Let's put it, or they may be a problem and may need some sort of discipline. Leaders should be held to a higher standard than the other employees. But you, in your role, may not honestly have the authority to address the issue, even if something is blatantly wrong to you, if it's not illegal, but just wrong. You're going to be stuck, and you probably won't be able to follow typical progressive discipline steps. Follow other options depending on the severity and your role. So generally, leaders are not, quote unquote, written up. They generally don't get a progressive discipline issue. Sometimes they're counseled and given a final warning. Sometimes they're terminated after one bad action, if it's bad enough. So if they are counseled, it may be by HR or other top people in an organization or a facility, but depending on your role will determine what, if anything, you can do in that situation. If you think something is going on that is inappropriate, you may need to go to another leader and report that, but it will depend on each situation and your role. All right. Any questions? I know I ran right up to the end here.
All right, so we have questions that have come in. So here is the first one. If someone posts on their personal social media and it's inappropriate / discriminatory, if it's reported to the ER, can we do anything? And does it matter if it shows that they work for us on their profile?
I would consult an attorney on that one. It is just from what you've just said in that example, it's impossible for me to tell you the right thing to do. I don't know what was said, if other people joined in, how all of that works together. But if it's a recent situation, then then I would definitely contact an attorney before taking any action.
All right, the next question is, some people consider BLM or Black Lives Matter to be a political statement. What is your view?
I personally, I do not consider that a political view. That is not going with it doesn't state support for either political party, for either candidate, for any candidates. If they said all lives matter, would you care? If they say Black Lives Matter, do you care? I know some people have taken the position that's not political and they're not going to fight it, and that is more of an issue of respect probably than politics, but that's just my view, and that is not a legal opinion.
Here is a follow-up from a different question. I have an employee wearing a Black Lives Matter face mask. Other employees are complaining. What should I do?
I would contact the attorney and see whether or not that violates anything. You know, we've got the issue of freedom of speech, which doesn't apply here, but it's not a political statement. So I think employers are coming down on both sides as to whether or not that's legit. And before doing anything, I would just make a quick call to an attorney. And, you know, there's another possibility that there is an attorney's opinion on the internet. If you Googled that, there's possibility of an attorney opinion on there, but that might be some guidance. But if that's not a Wisconsin attorney, you might want to be careful. And if you're a City of Madison employee or employer, it may be different also, because City of Madison has employer ordinances that are different from the rest of the state.
All right, I know we've gone a little bit over, so thank you guys so much for staying to ask your questions. We do have the CE credits up there on the slide for SHRM and HRCI. And just a reminder, you will get a copy of the slides and a link to the recording as well. And if you think of any questions after the webinar that you would like to ask Karen, don't hesitate to reach out and we will try and get you an answer. Thank you guys so much for joining us and have a great rest of your morning.
Thank you, everybody. Bye.